Hello and welcome everybody, and thank you for joining us this evening. This evening in Australia, where I'm coming from. It's probably very early in the day for some of you. I know Jean's starting very early in the morning in Canada. So the Forum of National Archivists welcomes you to the first webinar of the year. And this is an exciting session we've got ahead of us, exploring the vital intersection between copyright and archives. Before we get underway, though, I'd just like to introduce myself. So my name's Simon Froude. I am the Director General of National Archives of Australia, and I will be your host and moderator for this evening. A few housekeeping things. So as with all Zoom sessions, there's a chat function, and so if you have any comments that you'd like to post throughout the webinar tonight, please use the chat function. We also have the Q&A function available if you should have questions. So because this is an interactive webinar, we will have time at the end for questions from participants. So please feel free to pop your questions into the Q&A section. And I believe there's also the ability to like questions from other people, and we'll use that as a basis for trying to identify which questions we should ask first. There is also an interpretation function available, and you'll see that again down at the bottom of your screen. If you click on the three dots or the more button, that gives you the access to interpretation services. And finally, this webinar is being recorded and will be available on the ICA YouTube channel at some point in the near future. So today's webinar is a discussion that will centre on the key question of copyright and how does copyright impact archival work, and does it support what we do or does it hinder the archival mission? Unlike data protection and access rights, copyright is a property right that directly influences the acquisition and the management and the accessibility of archival materials, particularly in the digital era. Understanding the implications of copyright is crucial to ensuring that archives remain reliable, authentic, and accessible. So during the session, our expert speakers will present ICA's work in copyright advocacy, best practice, and education, while sharing some key resources and some steps to help archival professionals navigate copyright challenges effectively. We're very fortunate today in this session to have Dr. Jean Dryden and Malcolm Todd, who is the chair of the expert group on legal matters, and they will set out the products of the past few years and suggest some practical steps to support the ICA community. So before we get into the session, I might just give you a bit of a brief bio of our two presenters today. Dr. Jean Dryden is an archival consultant and scholar in Toronto, Canada, and a recognized expert on copyright in archival matters. She's a member of the ICA expert group on legal matters, and from 2015 to 2025 has represented the ICA at the WIPO Standing Committee on Copyright and Related Rights. She's the author of Copyright Exceptions for Archives, a checklist, which is a toolkit that enables archivists to evaluate how well their nation's copyright laws support the archival mission. And Malcolm Todd is head of policy at the National Archives UK, where he leads a team with responsibility for the UK's public record system, the reuse of public sector information, the management of Crown copyright and official publishing, and the impact of other government policies on the wider archival sector. He has chaired the ICA expert group on legal matters since 2019. This virtual event is part of FAN's ongoing efforts to foster open discussions and to collaboratively tackle the pressing challenges facing the archival community, and we're happy to do that in conjunction with the ICA and with their support. FAN would like to thank Jean and Malcolm for presenting today's webinar, and with that, I will hand over to Malcolm.
Thank you, Simon. Good afternoon or morning or evening, everyone. Just get straight into this. Okay, right. So you've had introductions to Jean and myself. I'm going to do a brief introduction to the expert group that we're part of. So the expert group on legal matters has existed for a bit less than a decade, and we've got multinational members. I think there's a call actually out at the moment for expressions of interest in a new one, particularly from Oceania or South America, but that's for another day. And then we have quite a wider remit. I took over the group at the same time as the expert group on theft, trafficking, and tampering was split out from the expert group on legal matters. And the remaining remit that we have is to do with those issues of those legal issues that engage and affect archives listed there, and we're talking about an aspect of the third one there, intellectual property. Okay. Jean.
Yes, my turn now. Just to set the stage for what we're talking about today, I am going to give you a brief overview of what copyright is. Copyright attempts to balance two things. On the one hand, the right of creators to control uses of their works and obtain a just reward for their efforts. And on the other hand, support for the public interest in access to those works to foster innovation and creativity. Copyright protects the expressions of ideas, not the ideas themselves, but the expressions of ideas in a variety of formats, such as books, photos, letters, diaries, maps, videos, and sound recordings. Copyright owners control uses of their works because they have the exclusive legal rights to reproduce, to publish, perform in public, distribute, post on the internet, and adapt or modify them. These rights eventually expire in accordance with national copyright law. After that, anyone can freely use the works. But on the balancing the rights of copyright owners, copyright laws also include exceptions, sometimes called users' rights, to copy and use protected works without permission or payment, for private purposes, and for purposes that serve the public interest in further creation and the growth of knowledge and culture. For example, education, research, libraries, and archives. Exceptions are always limited by terms and conditions. And I'd just like to briefly say what copyright is not. Copyright and access restrictions are often conflated, but they are entirely different matters. Copyright controls the right to make copies of material that is protected by copyright. Users of archives can often consult archival material, but making copies may be prohibited, not because of copyright law, but because of the material's fragile physical condition or to comply with donor agreements or institutional policies. However, prohibiting access to certain materials is different. Archivists restrict access to comply with applicable laws, such as privacy protection, freedom of information, national security, and the like, or to comply with donor agreements, or with institutional policies. For example, because the material has not yet been arranged and described, or because of its physical condition. Preventing users from consulting materials is very different from copyright compliance. If the material is not available for consultation, obviously it can't be copied, and copyright is not even relevant. So, restricting access does not mean that you've complied with copyright. So that's my overview. Over to you, Malcolm.
Thank you, Jean. So the next few slides incrementally we're going to take you into the implications that fall out of the nature of copyright and indeed the nature of archival material. There's a little bit of repetition in the groups of slides here, but there's a point to it, which is to get you closer and closer to what we're trying to do to assist the archival community here. So just to pick up on the title of the session, what are we wrestling? So first, it's worth considering, following on from what Jean's just said, that in the legal framework, what's the wrestling we need to be doing? Although there are international treaties and so on on copyright, and the most important one is the Berne Convention. Copyright law is usually a national law, and that it varies from jurisdiction to jurisdiction. There are provisions in the Berne Convention aimed at not harmonization, but comparable protection or equivalent protections. And even then, there are some anomalies in the way that member states of that convention have actually written that into their own law. And that means that it's actually quite difficult to generalize about copyright. We tried to do that in the expert group as far as it can be done, and I'll come to that a little bit later. But producing any guidance product or indeed giving a talk like this, it's impossible to get into the details of everyone's law. And that applies whether we're talking about jurisdictions or whether we're talking about individual institutions. So more on that later. But one of the biggest challenge, and I'm sure it's occurred to you while Jean was speaking, that copyright law wasn't really designed with either the functions of archives or archival material in mind. But then, notwithstanding, archival material is subject to the same laws as products of the publishing and entertainment industries, which are much more likely to have had an overt commercial driver in their creation, okay, rather than archival material which exists because of other types of activity of human discourse and interaction. So that means we need exceptions to square these things. Some people have good ones, some people have really great ones, really lucky people there. But in lots of countries, the exceptions available to archives are incomplete. And that's a problem. And it means that we have a job of work to advocate beyond our profession to get people to understand our issues, which of course means explaining them in the language of people who aren't archivists, which can also be quite challenging. And then the other bit of the wrestle is actually about practice. So just expanding a bit on Jean's explanation. So copies, and this is a point that's well, Jean and I debate it from time to time, I think it's true to say. Most of the issues that we have with copies are present in the analog environment, but the digital environment expands them, and I several times referred to them as the same issues on steroids. So we might be thinking that the reservation of the right to copy to rights owners only really applies to copies that you're giving to somebody else. In fact, it doesn't. It also applies to copies in our preservation systems on our servers, including our web servers, potentially in the browser caches of our users, and so on. So you can actually infringe copyright even if you're not actually disseminating the information to an end user. And then most archival institutions don't have the rights over large swathes of their collections, copyright over that material, and that's a bit of a challenge. If you're an in-house archive that does have some of that, then you're lucky. A lot of people have to deal with a lot of complex issues right across their collections, and it's hard to generalize what those issues are according to the content and so on. And then there's another particular problem. Because of where archival material comes from, it's quite likely that the person who did the act of creation that copyright law seeks to reward never actually identified themselves or asserted that that was their rights. And this is where we get into the very thorny subject of orphan works. So it can be unclear or impossible to establish who the rights owner of archival material actually is. And there are some things that probably ought to be done systematically at or before acquisition, because you may never get such a good opportunity again. And we'll say a bit more about that later. And then I want to talk a bit about what the overall challenges of this is for us as a community. So it's really wrestling with something that is a bit alien to a lot of aspects of what we deal with. There's several levels of abstraction going on here from what we are accustomed to in a lot of our professional discourse. So Jean already covered the first bullet here, that copyright is a property right, but it's an intellectual property right. So it won't help you very much if you're used to dealing with archives as physical property, because it's abstracted into protecting the expression of ideas rather than an artifact. And then there's a thing about our general professional métier, and Terry Eastwood, whom I'm sure a lot of you know, put this very well in describing archivists a couple of decades ago as incorrigibly practical folk. And I think it's true. And then in a lot of cases, the type of curation we do isn't necessarily about the content itself. It may be, but a lot of the processes we carry are about the documentary forms to preserve the authenticity of archival material, rather than getting deep into the content and considering its authorship and the circumstances of that and so on. I'm not saying no archives do that, of course they do, but it's not necessarily something that's done right across the entirety of collections. And then you don't get a lot of help from general knowledge, if I can put it that way, about what copyright is and how it works, to grapple with how this affects archival material and archives. Because the main things that I think the man or woman in the street understand about copyright is actually really about commercially published material, and not the sort of stuff we're usually dealing with. Jean, would you like to pick up here?
Okay, well, so what are we doing about it? Well, we've done rather a lot, either through my initiatives as the ICA's representative to WIPO, or through EGLM itself. So next slide, please, Malcolm. So this slide represents the various copyright initiatives that either I or EGLM has done. It did not start as a coherent plan. The first item was a checklist of copyright exceptions that I did in 2017. It's an adaptation of a similar work for libraries done by the Electronic Information for Libraries organization. And they were kind enough to give me permission to adapt it for archives. So it's a means of evaluating your checklist, evaluating your copyright law against what an ideal copyright law would contain. So that has been available. And then the centerpiece has been the declaration. which was approved by ICA's executive board in 2022. This was developed by EGLM. We felt it was important to have a high-level statement to highlight the needs of archives and to distinguish archives from libraries. As you know, our archives and libraries have similar missions to acquire, preserve, and make available material of enduring value, but our holdings are quite different. And in my role at WIPO, I've always been trying to raise the profile of archives and not just having everyone assume that it's just a funny kind of library. So this declaration was developed by the EGLM itself, and it stands in contrast, I guess, to a similar declaration that the International Federation of Library Associations has, which represents the library perspective. When we were planning the declaration, we recognized that guidance was always also needed to administer copyright within institutions, but it could not possibly be done in a single document. Declarations are very high-level documents to set out the broad strokes of what we need and what we stand for. So therefore, a toolkit was needed. And Malcolm, perhaps if you could go to the next slide, not only did we recognize that, but the need for the toolkit was reinforced by a workshop session at the Abu Dhabi conference, where we held a workshop on what the priorities should be for EGLM during the next period. And so as you can see from the slide, we called for work item proposals, and we discovered that archivists do not generally find copyright easy, and the toolkit represents something of more practical relevance for their institution. So we'll talk more about the copyright toolkit later. And yeah, thank you, Malcolm. So the toolkit is good, but to derive its full value requires a good understanding of copyright. And in my experience, archivists could benefit from a better understanding of copyright. And so if you could go back to the previous, oh, sorry, I've got two screens going. You are where you should be. I felt it was important to develop a course, an introductory course on copyright for archivists. This course I have been working on this course for about 5 years. There were interruptions due to the pandemic and other factors, but I am very happy to say that the content is complete, and technical testing started yesterday. And we don't have a specific launch date yet, but spring of, sometime before June 21st, 2025, we will be the ICA will be officially launching it. And the course includes a module on managing copyright in an institution, and of course, we'll refer to this toolkit as a resource. So you can see that we have a suite of ICA resources to support members in dealing with copyright. Each has a different function. Although they're related, each can be used separate. And other work not related to copyright is underway. Members of EGLM are looking at legal issues in archiving local oral histories and in reassessing the 2006 principles pertaining to archival legislation. But our focus today is the toolkit. We do need your input to review it to see if it works and how it might be improved. But more on that later. So back to you, Malcolm.
Thank you, Jean. So we're doing something a little bit different with this product. On one level, it operates as guidance, but on one level, it operates as, well, which is why it's called a toolkit, a kind of workbook. And we're still discussing amongst ourselves, and we will be talking to people about the exact best way of structuring that so it works best for people. What we're doing is devising a modular construction that can be customized, and people can interpose their own specific either nationally or even institutionally guidelines, policies, laws and things into their copy of it, so that they can end up with a "this is how we do it here" kind of outcome. Obviously, that's quite demanding. It's a slightly unusual way to proceed. We think it's probably going to bear some fruit, but we're at a fairly early stage of it. And what we try to do in it is segue from the sorts of things that, and actually segue in the same way that we have in this conversation already, from the issues of what is copyright conceptually and practically, but then so what, but then also what that means for the practice of archival institutions with the material that you have. Of course, there are, if you go back to the ask from Abu Dhabi, the delegates wanted something of practical relevance to their institution. Well, you bet they did. But of course, how many archival institutions are there? They've all got unique collections, etc., etc., etc. So that's a challenging thing to square. It's, you know, it's why we've got this customizable construction approach in the design. So what we've done is we've tried to do two things. The first is to urge people to consider what they've got and know their collection, so that they can actually take effective action in line with copyright law, and also participate, hopefully, in these discussions within ICA and maybe more broadly, if that's not adequate. But then also to think about how their situation, springing from their collection, actually means that copyright engages with the functions of carrying out the archival mission in that institution. So there are sections about where copyright is likely to arise at acquisition, and that essential point about that might be your best chance to investigate and capture metadata about the rights subsisting in that information. You certainly may not get that chance again in quite the same way. How it bites on preservation functions, and then, you know, the one that is a bit more obvious to all of us, how we give access to things, and making a distinction as to whether that's the provision transactionally of individual copies to individual researchers, or doing it on a much bigger scale over the internet. And then, because we know that not everybody, you know, it's pragmatic judgment, not everybody can deploy the resources to look at all those things in exhaustive depth, that actually how you manage, how you structure your management of copyright risk, or how you might structure it. I dare say there are other ways of doing it. And then a sort of adjunct to that is something that some archival institutions can do a little bit, and some are only able to do barely at all, which is consider what support you are able to give to the users of archival services that you're managing. Yeah. So what we're trying to do with the toolkit aspect is to support and guide people's inquiry into the issues. So and this should smoke out whether the exceptions in your jurisdiction, the copyright exceptions, are actually adequate to the challenges that you have in managing your collections. And as Gina said, this is intended to be complementary rather than duplicative of other ICA resources about copyright. And then we're also putting in some boxes describing particular scenarios that exist in some jurisdiction dealing with some of the more knotty problems, in case it's instructive to people more broadly. For example, the problem of orphan works and how that's being approached in jurisdictions like the EU and Canada. Okay. And then I just want to say a bit more about collaboration to develop this product further and make it maximally useful, because we don't have every perspective. We can work on this till the cows come home, but we need to know whether what we're producing is going to be useful to real archival scenarios in the community. So the first thing we've decided to do is to talk to groups like this fan conversation. And then we think that people will be able to take the final product when we're there, and we're not there yet, the final product that EGLM produces, and collaborate either within an institution or between institutions or within a jurisdiction or within a ICA region or something like that, to customize what we've put before them to make it work for them, so people can share knowledge. We're quite excited about that aspect of it, because it's a new way of doing this, we think, within ICA. Somebody might shoot me down in flames. It might have been done before, but it seems to us the best way to proceed. Okay. Jean, would you like to take the next few points?
Okay, so we, because this is early days, we may split the guidance and the activities, which are designed to make the toolkit customizable. We may, separate the guidance and the activities and create kind of a workbook format, depending on your feedback, what would be most useful. That we want something, of course, that will be useful to ICA members, so that will depend on you. And we hope to be communicating again in Barcelona at the Congress. By then we will have completed our consultation with the Caribbean regional group, and we hope have something more concrete to present in Barcelona.
Thank you, Jean. Now you're probably all thinking, why the heck don't we get to show you some of the things? So I'm going to do that now. So we did a soft launch of the toolkit, really to help us share it with Carbica initially, but there's a healthy number of downloads showing on the ICA website, so I think quite a number of other people have found it, even though it wasn't and consciously wasn't publicized at the time. So it's on the ICA website in the digital resources section. So and it's very clearly at this stage it's not ICA guidance because it's work in progress. So I'll just run you through what the shape of the thing is at the moment. Some of this, some of the logic of it will be familiar to you from what we've been talking about today. So there's a general introduction which talks on a little bit about, but doesn't labor the issues in the declaration and the sorts of issues about basic descriptions of what copyright is about that Jean's been covering here. and then says what the particular issues are for archives. Okay, and then segues into this section about the importance of knowing your collection and giving some pointers as to why that matters and in what way we think you need to know your collection to manage copyright effectively. Okay, and it's really as it applies to your remit and collecting activity. And then along the way, it starts to give some examples about how things can vary quite widely between jurisdictions. There's the urging to acquire as much copyright information, metadata at or prior to acquisition. And then a very speculative broad schema of what sorts of issues are likely to loom larger with different types of archives. It's very impressionistic, but we thought that might be helpful to people. Okay. So we've got national archives, local government, corporate, community archives, and then higher education, literary archives, and some private ones. It's not a totally systematic or comprehensive breakdown. We thought that might actually help some people in thinking, wow, I really need to look at that first and prioritize that. And then there's a section which is pointing quite heavily across to the exceptions checklist and other guidance produced by Jean as WIPO representative, and also the course that she has done a trailer for just a few minutes ago to talk about what laws apply and studying and improving knowledge of what law applies to copyright in archives in your jurisdiction. And then some hints about so this thing about the primacy of laws, which law is more important, does this one trump that one? That can vary according to things like interpretation rules in the jurisdiction and so on, and you may need legal advice, but it's just pointing out that there's an issue there. If, for example, your archives legislation requires you to do X, particularly thinking here of a national institution, but you know, you don't know how the heck you can do it because somebody subsequently passed these other laws that seem to suggest that, oh, I don't know whether I can really do it like that or do it in the way that my users expect. And then there's a section explaining about the different types of exemptions that may exist. This isn't quite the same as what's in the checklist, but it's some points that come out of an empirical look of how some exceptions operate, and a discussion of how how that might make things harder or easier. And then to go back to the toolkit aspect of the product, recommending that people collect and maintain the applicable legislation, and aggregate into the toolkit that for their future reference and use in the organization. Okay. And then we move into that archival function, a sequence of archival functions where we think particular things are advisable in terms of getting to grips with copyright. I've already talked a bit about that. So there's one about acquisition, then preservation, and there we're referencing the very useful World Intellectual Property Organization Preservation Toolkit that came out last, I think it was summer or autumn, I can't remember exactly. Again, as with the ICA input, seeking to reference and point rather than repeat the whole thing. And then stuff here about access, and as I said earlier, we talk about transactional one-to-one access, if you like, but we also talk about doing it at scale, where obviously we have to talk about cross-border issues. And then some things in public policy or intellectual property practice to do with licensing and reuse and open data. So, and then the issue about what, if any, support you're able to provide to the users of your services in the area of copyright. Obviously, we're being realistic about that because we know that it's going to be limited, but it's just trying to say what different types of things could be done, which segues, I think, quite well into the section here about risk and, you know, what sort of risk, how to work out what sort of risk is within the appetite of your institution and your ethical codes, which might be the ICA code, but you might actually have ones coming from other professions that you and your colleagues might be in, for example, in the UK and a lot of central government jurisdictions. There is a thing about the rule of law that might be in a code of conduct for public officials, that sort of thing, which will reduce the ability to take a risk-based approach beyond a certain point. Okay. And then we try to point out what sort of characteristics of a collection produce what sort of risk for you, what sort of copyright risk. Okay. And then a brief consideration of whether the behavior of your researchers might impose risk onto you and what you can do to make sure that it doesn't transfer to you as an institution. And whether there's a role on the internet, whether there's a role and how far there's a role for just taking things down when you get a complaint. And then just towards the end, we've got, that's the placeholder for people to collect their own legislation in their own jurisdiction. We are considering whether we need or whether it's helpful to try to produce any model paragraphs for copyright policies that institutions might do. I think that might be quite hard, but we might be prepared to have a go. On the risk management point, whether we ought to produce some boilerplate text to help people write disclaimer notices so that the archive is making it clear that just because we've been able to make this available to you, you can't just do what you like with it. And there is where we got to. So, just to go back to the main slides. Sorry, I'm just making sure I'm still in slideshow view, which I am now. Thank you. So just before we throw this open to questions from attendees and do our best to answer them, I just wanted to just cover briefly and speculatively some things to do with copyright and artificial intelligence, which is obviously a really hot topic at the moment. It is very difficult to map out where this is going to go generally, let alone for us as a community. I'm sure you're all aware of the various controversies there are in various jurisdictions about, about this, and various big issues that are bubbling up. So there's things like the New York Times lawsuit against Microsoft and OpenAI about harvesting of newspaper content over many years. There's an active policy discussion in the UK about artificial intelligence model training and copyright material, which has produced quite a large response to a public consultation. I think really any organization holding significant quantities of information and providing information services to the public is going to have quite a lot of disruption, if you like, to what they're doing as a result of AI. Now, some of that disruption could be extremely positive and helpful in terms of processes that we need to carry out, and whether they can have machine assistance, or whether our service delivery can use it. But then there are some more existential questions about intellectual property, copyright included, about, for example, does artificial intelligence itself, without a human instructing it on the creative points, actually create any new intellectual property, any new copyright? It looks as though if you like, the holding pattern presumption is it probably doesn't, but we don't know. Somebody might legislate or get something through WIPO to saying that it does. We just don't know. It hasn't happened yet, though. And then should training of large language foundational AI models on copyright material be permitted, and how? So obviously there's that big tussle between creative industries and AI companies about on what terms. Does it need to be done under a license with compensation, or in the interests of economic growth, technological development? Should it just happen anyway? And then I think for us, there are risks about, well, if archival material gets sucked up and harvested at an industrial scale, what's that going to do to our concerns for providing access to documents in context, reliable and authentic information, and so on. So I think that in some ways, I've been bombarded in the last couple of weeks on LinkedIn by people sharing the fact that books or articles that they wrote that are in open access repositories have clearly been, and traceably, even though there's no acknowledgement, been used to train AI models. So I think it's true that we've got an awful lot to keep an eye on, an awful lot to think about, some things to engage with at the policy level. And, you know, I think in the end, there'll be a lot of change to the way these things look over the next few years. And all those things are, even without considering the hallucinatory effect that artificial intelligence can have at times. So that's incredibly high level and not particularly technical, because I couldn't do a particularly technical rundown of those issues. But I think it ought to be fairly apparent from the foregoing, before we got to those issues, that there's a lot already, but this is going to mean there's a whole lot more for us to deal with. Okay. So we've run through the presentation at about the right time. Simon.
Thank you, Malcolm, and thank you, Jean. That was fascinating. So, for members of the audience, please feel free to put any questions that you might have for Malcolm or Jean in the Q&A section of Zoom, and we'll get to those. I'll just give you a bit of time. I might, Jean and Malcolm, I might start off with a question, if I may. So one of the questions that I've always had sort of floating around my brain when it comes to copyright and archival material is to what extent should archives go to seek out and find the copyright owner of an item? How far do our responsibilities sort of rest with us? What's the extent of that?
Well, that is a question that floats around in my brain also a lot. Like, when do you stop? If material is published, like a book, you know, the copyright owner or the publisher is right there before you, and that would be where you start. But with archival material, like a letter or something, there are many avenues you could go down to try and find out who the rights holder is. And I think it's, at some point you have to stop. I know that many jurisdictions have tried to come up with guidelines for, well, if you check this and this and this and this, you're fine. But there's always something more, and the risk is that some, if you've gone through the checklist and figure I cannot find the rights holder, and you, for example, put it online, then there is a chance that the copyright owner will come out of the woodwork and challenge you and say you didn't do your due diligence. So in the, I don't know the answer to this, Simon, but to me that's the jurisdictions who have tried to come up with a solution for orphan works. Generally, the approach that they take is that, well, yes, after a reasonably diligent search, you can use an orphan work, but no one has come up with a clear guideline on what is a reasonably diligent search. And that's for institutions that are very risk averse, that scares them off. To others who are more risk tolerant, they may take a chance. I have not scanned jurisprudence throughout the world, but I am not aware of legal, court case. There are very few court cases in which a copyright owner has indeed come out of the woodwork and actually sued an archives. Usually it can be dealt with a takedown notice or an apology, or maybe pay some money, or a challenge does not start with a lawsuit. So I think the risk is relatively low given the limited value of most archival material, the limited monetary value of most archival material. To hiring a lawyer and suing somebody is expensive, and if this item is not worth much on the market, nobody's going to bother going to court. So I didn't answer your question, but I talked about some mitigating factors.
Yeah. So I think another angle is if an archival institution's got benefit of a full set of exceptions, then it's not actually your problem, and that's the aim of the exceptions in an ideal world. I think it's true to say. I mean, it does become a problem for your users because you're unable to transmit comprehensive information about that.
Yeah. So thank you, Malcolm and Jean. So Jean, just picking up on something that you mentioned in your response there, you talked about the notion of takedown notices, and I guess the the practice of I guess for the less risk averse organizations going ahead and promoting and making information available on the basis that if anybody does make a complaint, you will take it down. Is that seen as acceptable?
I don't believe it's ever been adjudicated in court, but it is a very common practice where it's a small piece of evidence. If you put some sort of disclaimer on your website, this is for a digitization project, saying that although we have tried to locate the copyright owners in all cases, we have not been successful. If you feel you have a copyright interest in this, any item on this work, please get in touch with us. I mean, it doesn't say you're going to pay, or it doesn't say you're going to, do whatever it is they want. But it does indicate an understanding that maybe a risk was taken, and if somebody does challenge you, your first step is to take it down, investigate their claim, which may not be at all well-founded because there's a lot of nonsense out there, and figure out what they want. Start the conversation. If it turns out they want an extraordinary amount of money or they're going to sue you, then keep it down. Like, don't put it back up. But if their claim is unfounded, or you work something else out, you can put it back. But so a takedown, as I say, it's very, very widely used, and I have small bits of anecdotal evidence that it works. And sometimes somebody challenges you, or at least there's a, they say, oh, I saw my stuff on your website, and in fact it works to the institution's benefit, because the person says, and my family has more stuff which we would be glad to donate to you, or you spelled my name wrong. And I mean, it's easy to correct somebody's name, and if they have more records, great. It's so it can work. Taking the risk can work to your benefit.
I think it's worth just saying one thing we covered in the declaration is that in general, the activities of archives are not rivalrous or detrimental to what most people want to do, and that copyright seeks to protect. I mean, if we're trying to make commercial revenue, that's a whole separate ballgame, you know. But if we're not, and we're just carrying out our core function as an archive, there's some stuff in the Berne Convention about the framing, or what member states of the convention are permitted to do in terms of the framing of exceptions, and I think that it's quite instructive. It's Article 9. It's quite instructive in risk management, in the sense that it sets out that countries in the Berne Union can set out exceptions that permit. So it's the reproduction of works in certain special cases, provided it doesn't conflict with the normal exploitation of the work. That means by the rights owner, and does not unreasonably prejudice the legitimate interests of the author. So I think you could, and certainly if you came to a detailed court case, you could derive some sort of a defence from some of that you're not really interfering, or not beyond a certain point interfering with the property right that somebody else owns.
Yeah, thank you, Malcolm, and thank you, Jean. And Sharon made a comment in the Q&A about obviously the importance of documenting your search when you're looking for individuals. So you've actually got the as good all good archivists and records managers, you make sure you keep your records and evidence of what you've done. There's a there's a question in the Q&A come through from Alexandra Milic, and if I've read it correctly, the question's around whether the issue around copyright and copying material is the same for when you're scanning documents as well. And I'm assuming that it makes no difference, but I'll hand that over to both of you to respond to.
I think it is the same. You are creating a copy if you create a scan, if that's what the question means. Yes.
Thank you. Just having a look down now. We've got a question from Hugo. I'm not. My capacity of speaking anything other than English is very poor. So I'm hoping somebody from the ICA will be able to interpret the question from Hugo. So whilst that's being done, I might nip down to the question from Lehigh Cohen, so from the National Library of Israel. So they say that they're facing the challenge of making archival materials available to the public, so open access via library website, as making them available to the public is a right reserved for the copyright holder. We'd love to know if this is a challenge the committee has identified and looking to resolve it by fair use, while keeping in mind some materials can probably not be available to the public this way, such as commercial photographs. So any thoughts, Malcolm or Jean?
Well, I have some thoughts, as I always do. It would all depend on whether your national copyright law has a fair use provision. Not every country's copyright law does. So if your law doesn't include fair use, obviously you can't rely on it. In the United States, because they have a fair use, an open-ended fair use provision, that's what archivists rely on for their mass digitization projects. In Canada and in some other British Commonwealth countries, we have a fair dealing provision that is not open-ended. There's only 8 allowable purposes, and the Supreme Court of Canada has given us 6 factors to evaluate in determining if the use is fair. But one of them precludes wide dissemination. So it all depends on your national copyright law, whether fair use allows you to do it or not.
And
Thank you, Jean.
In that particular scenario, it could also depend, potentially, though Jean's right, it's likely to be the copyright law, but it could potentially be something relevant in your library legislation. For example, if you're a national library that has specific deposit rights, legal deposit rights, and is able to make things available as part of that function. But I'm not assuming that it is there. You haven't said that it is, although it applies to archival material, it probably wouldn't.
Wonderful, thank you, Malcolm. We've got another question from Stacey, but before I go to Stacey's question, the wonderful people behind the scenes here at the ICA have translated Hugo's question. So what is the model for cooperation between archives and AI owners to guarantee archives copyright?
So if I'm getting this correctly, I think I'd say 2 things. The first is that for the material in archives, archivists and our obsession with provenance ought to be extremely helpful to rights owners, because we have a commonality of interest in those things being explicit. So some of the more outlandish threats to rights owners from generative AI in particular are probably lessened by archival material, in the case of archival material, by that. That's not so much a model of cooperation as a commonality of interest, though. I don't know what else to say.
Well, I think the answer is nobody knows for sure, because nations around the world are trying to figure out what to do, how to legislate AI and ownership, and who is the author of an AI generated work, and is that different from an AI assisted work? It's a rapidly evolving situation, and the legislation has not caught up with the technology.
As happens very frequently.
Mm-hmm.
Thank you both. So we'll go down to Stacey Anderson's question. So she said, can I just clarify something that was said at the start? providing access and making copies can be legitimately prohibited to comply with applicable laws or on the basis of institutional policy. Is that right? Stacey's often encountered challenges by colleagues that this amounts to perceived censorship and that archivists don't have a right to censor materials.
Well, I was the one that said that, but complying with privacy laws, for example, or national security laws, restricting access for reasons such as that, you have to obey the laws of your country. Copyright does not, it's not an island. It interacts with the whole legislative structure of whatever nation you live in. And of course, you're in complying with laws like protecting the privacy of individuals is not censoring things. You're if you were to do anything else, you'd be infringing somebody's privacy. So I think people that are looking at it as censorship, they've really got the wrong end of the stick.
Malcolm, do you have anything to add to that?
Not sure I do, really. I agree with that. I mean, you can't, if you don't have a lawful route to making copies to do certain functions, then you have to act accordingly. I mean, that may not be the only way of providing access. It may be the only access you can do is on site, if it's constrained to that degree.
Okay, thank you. Questions come through from Francis, just asking whether copyright applies in archives, and I think from what we've heard today, I think the answer is quite squarely yes, it is, and it's quite a significant problem for us all.
He's actually talking about copyleft.
Oh, sorry, copyleft. Yes, I misread that then.
Well, copyleft is, I don't think much about it, but it's kind of a non-legislative movement, I guess. I could be, to ensure greater access for possibly than copyright law provides. So, but to copyright compliance within your institution involves complying with the copyright law of your country. So copyleft would be pushing the boundaries a little bit, in my view anyway. It'd be somewhat risky.
Sorry, Jean, just for those of you, for those of us who aren't familiar with copyleft, are you able to explain what it actually is? Because it's not something I've heard of before.
Well, somebody has been looking at Wikipedia in the chat. Legal.
Thank you, Andy.
Yeah, thank you, Andy. So I can read it. The legal technique of granting certain freedoms over copies of copyrighted works with the requirement that the same rights be preserved in derivative works. So it's the freedom to use a work for any purpose and the ability to modify, copy, share, and redistribute the work. That sounds like very much like Creative Commons licenses. So, but copyleft is, as long as it's consistent with, copyleft seems, it's more than Creative Commons licenses, and it seems to me that it would apply within, as long as it's within the framework of your national copyright law.
Excellent, thank you. Well, there you go. I've learned a few things today. That's excellent. So just going back to the question that we had from Stacey around this, that whole notion of censorship, she's just come back and asked whether it would still apply if the withdrawal was based on an institutional policy rather than a legislative basis.
So if we're getting a bit away from copyright here by the sound of it, but quite happy to say, well, if you look at the ICA access principles, and I think the ethical code, then yes, that probably would be sensitive. Censorship. But you know, I wouldn't like to, by implication, criticize any one institution about something because I don't know what the circumstances are that are being thought about. But you know, that certainly there's some ICA collateral about such issues.
And I think I'm just thinking about some of the issues that we face in Australia and many other countries around the world do with, you know, the material that we've got that might relate to First Peoples and First Nations. And, you know, there are particular sensitivities around that material that wouldn't be in national law, but which you would not release because of those sensitivities. And that's not seen as censorship. That's you know, that's listening to their knowledge authorities. So yeah,
agreed.
Thank you, Malcolm. We've had a question from Luke. So he's just curious if Crown copyright exists outside the UK in places like Canada and Australia. Are the Crown bodies there that this, you know, yes. So Malcolm.
Well, yes, it does, but it's those Commonwealth jurisdictions have their own Crown copyright. Is the answer to that? So I'm not pulling the strings from Q on Simon or Leslie Weir's copyright management, much as of course I'd like to. Yeah, it's a constitutional question. It's an interesting one. Yeah.
Yes, and Canada does have a crown copyright provision in its act, but there are different crowns. There's the Crown in the right of Canada, but also each of the provinces in Canada is the Crown in the right of Ontario, for example. And all those are different from the Crown in the right of Australia or the Crown in the right of New Zealand. So yes, we have Crown copyright, but it's nationally or provincially there are different entities known as the Crown.
Do you have that in Australia, Simon, with the states? Wouldn't be with the territories, would it? But
I'm just trying to think. We obviously certainly have it at a national level. I'm just trying to think if it differs for the states, and I don't think it does. I think it's just it's a single.
It's at the Commonwealth level.
Yes. Yeah. Now I could be wrong on that, but
well, I was just going to say that would make things simpler in Canada if the provinces didn't also have Crown copyright. So.
Yeah. So a question come from Roy Starkey. And I just thank you to all of the participants who are sending through questions. It's really good to be able to dive into this topic with both Jean and Malcolm. We've obviously got, you know, years and years of experience here. So and there's some great questions coming through. So in the UK, we are bound by what I regard as a ridiculous situation where the expiration date for all unpublished literary works has been reset to 2039. This effectively means that researchers cannot obtain permission to reproduce, for example, correspondence or notebooks and diaries. Is there any prospect of a pragmatic exemption being put in place for such cases?
So I need to be careful because I'm a public official in the UK government. I'll stick to the facts. So there was an exception legislated for bringing this forward, but it was quashed. I think the Intellectual Property Office had it revoked because there was a Human Rights Act issue with deprivation of property that couldn't be done in law without compensation. I just want to pick up a couple of things in Roy in your wording though. Cannot obtain permission isn't quite right. You know, the issue is about whether there's an exception that allows you to do it or whether it's out of copyright, not really whether you can obtain permission, which is a bit of a separate issue. Because if you can identify the rights holder and then come to an agreement with them, you can always do that. But I think you're talking about stuff that's so far in the midst of time that you can't. So now the more this is argued about, we do appreciate that it's a serious issue, because we're affected by it as well. The closer 2039 is getting, it's a very, very tough thing. But I have to stick to the UK government line, which is that it's not possible to legislate in the way that the government tried to in the last decade.
If I can add, Canada has an equally dumb, I'm not a public official, so I can express my opinion. Our expiration date for similar material is 2049. So it's even longer. A big whack of stuff is going to come into the public domain then, but it doesn't stop people from making copies for research or private study under fair dealing, and it doesn't stop people from actually getting permission. That's just when the copyright expires. So it really isn't the blockage to use the way it's stated in the question, but it's a long time.
And I think it's worth just saying two things. I mean, the first is that it's the end of a 50-year transitional period about unpublished copyright, because in 1988, the Copyright Designs and Patents Act addressed much more comprehensively than previous legislation had unpublished material. So that's the genesis of it. But also there is in the UK the orphan works option. There is an orphan works, let me get this right, licensing scheme, not an exception, which is what there is in the EU, but a licensing scheme. But it's not perfect. But that option is there.
Wonderful. Thank you, Jean and Malcolm. A question from Nancy, and I note we've got about probably about 10 minutes left of the webinar time. So if you do have any other questions, please send them through. Is there any way that the WIPO could suggest an exemption for archives for revisionary rights in the Canadian Copyright Act?
The short answer is no. WIPO doesn't tell nation states what to do about their Copyright Act. At WIPO right now, one of the long-standing agenda items is a treaty that would provide a consistent minimum set of exceptions for libraries, archives, and museums that would permit them to fulfill their mission, like making copies for research and making their holdings accessible without copyright being a barrier. There is the NGOs, like the non-governmental organizations such as the ICA, even though the ICA is an accredited observer, the ICA cannot introduce documents or draft treaties, for example, onto the floor. Only member states can do that. And even though we have a draft treaty that would accomplish what archives need, no member state is willing to step up and introduce it. They're all delighted to be second and third and fourth in line, but nobody, for a whole combination of complicated political reasons and global reasons, excuse me, to actually introduce it. So we have to keep lobbying behind the scenes. But reversionary right is not one of the main points of our draft treaty that we have in mind, although I agree it needs to be fixed, but it's purely a domestic domestic issue. So write to your MP.
Thank you, Jean. So as I said, we've got a few minutes left before the end of the session. So if anybody has any last questions they'd like to ask, please send them through. Whilst we're just waiting to see if anybody else has got a question, I might just throw one at both Jean and Malcolm. You know, does the transition to a sort of a more digitally focused archival collection make dealing with copyright easier or harder?
I vote harder.
I think that's true. I think we've got the same issues, but they're exaggerated. So just an example, let's take preservation, for example. It is very true that sometimes in the analog world, material is copied for preservation reasons, but it's not a routine thing. It's done for specific conservation reasons on specific items. In the digital world, you can't preserve anything without creating copies, whether that's within your preservation system, or to get them into your preservation system in the first place, or to migrate the encoding format of material or anything. So that's just it's just one off the top of my head. It just amplifies the effect to I think an exponential degree, really.
Yeah, thank you both. That's good to know. And look, I mean, my gut feel was certainly that dealing with digital material would make it much more complex. But it's good to have that that sort of view supported by both of you. I'm just checking to see if there's any other questions that are coming through. I don't think so. So one of the, just before we sort of finish up, there was Malcolm, very early on in your presentation, you mentioned the fact that there were some, really good examples of copyright frameworks and legislation out there, and obviously there are some very bad ones that are hard to deal with. Can you give examples of the good pieces of legislation that we might turn to if we've got an ability to influence within our own countries?
Well, if somebody hadn't mentioned this reversionary question, I probably would have said Canada 5 minutes ago. Jean's shaking her head. We're not badly provided for in the UK. There's the issue about the 2039 rule. So one thing that public bodies have, for example, in the UK, and I don't know how widespread it is archives have the benefit, if they're public authorities that have to provide access to information pursuant to a statutory provision, is that there's a general public administration exception, which allows that sort of public register type stuff to be done remotely to suit the. Now, the interesting thing is that it's framed as to benefit the user, benefit the citizen in inspecting such information, and that applies, for example, to documents held in the National Archives, which means that we can transmit things over the internet without infringing. But that is qualified, though, because, as you'd expect, because of the Berne Convention, that if that material is commercially exploited, then the exception doesn't apply. So if the rights holder is making money out of it, it's in commerce, then you can't do that under the exception. So there are all sorts of ways, and we get into this a little bit in the draft toolkit, that exceptions can come from various places. They can be specific to archives. They can be framed in terms of libraries, but helpful to archives, even though they might not be mentioned. So it's helpful if they are. Or they can come from a whole other place, like that public administration example. And there is actually quite a good publication. It's in the very sharp-eyed people might have noticed in the footnotes of the toolkit. There are a couple of scholars who have published and occasionally update exception coverage internationally. I'll just try to give you the reference. Actually, I'll put it in the chat if people would like. Just excuse me, I'm scrolling for it.
Yeah. While you're looking for that, I know nobody's copyright law is perfect, but I like to look at countries that have recently amended their copyright laws and done, in my view, quite a good job. And that is Singapore, who just amended their copyright law in 2021, and they include a fair use provision, and it's really very, very, very comprehensive. So I'm sure that archivists in Singapore could find problems with it, but that's the one I turn to as one of the more recent ones that's so comprehensive and recognizes the digital environment more than some older laws do.
Wonderful, thank you, Jean. And Malcolm, thank you for your answer, and also for putting that information in the chat. So I think there's a question
URL.
just come through.
Sorry, Simon.
Yeah, that's all right. That's great. Thanks, Malcolm. So there's a quick question's just come through from Ted Taylor. We might make this our last question. So for digital archives, are there documented best practices on the responsibilities around documenting and managing copies?
I'm not aware of any.
No. It sounds like a job for someone to go out and create some best practice guidelines for digital archives. All right. Well, we might wrap up the session there. We're pretty much bang on time. So, can you all please join me in thanking Jean and Malcolm for a fabulous presentation and some great answers to the questions that were raised. It was really great to be able to share this session with you, and I on behalf of FAN, we'd like to thank you for your participation, and I think it was a great session, and thank you very much. I'd also like to thank the ICA for their assistance in setting up the session today and for all of the work that they do behind the scenes, and of course to all of the participants who have come on and joined us. I think we reached around about 140, 150 people for today's webinar, which is absolutely fabulous. So we'd like to, FAN will obviously be running more sessions throughout the year on a whole variety of topics, and we'd hope that you all join us for the next session. So with that, I'd like to say thank you very much to everyone, and goodbye.
Thank you, Simon.
Thank you.